everyone. Welcome to Wealth Redefined. I'm your host, Michael Reynolds, certified financial planner and owner of Elevation Financial. Thanks for joining me today for this episode on basic estate documents everyone should have. We're going to talk a little bit about estate planning today. Don't go to sleep yet. I'm going to try to keep it interesting and simple. I know a lot of times when we hear the word estate planning, we think, oh, that's just for wealthy people or maybe later in life or stuff that I don't need or it's complicated or expensive. I'm going to try and dispel all of those myths and talk about a basic set of estate documents that everyone should have. And I'm going to keep it as simple and digestible as possible so that it illustrates that these really are universally important for generally everybody, and they don't have to be expensive or complicated. And we're going to kind of boil down what each one means. So generally, estate planning is all about making sure your property, your assets, your money gets passed on the way you want after you're gone. It lets you also make decisions about your own health and your money if you can't make them yourself. So a solid estate plan helps protect your loved ones and to make sure that your wishes are followed. It can also help avoid fights among family members and make things easier for them after you pass. So again, as I mentioned, estate planning does not have to be complicated or expensive. And the exact steps you take will depend on your situation and goals, but there are some basic documents that can make it easier. So a complete estate plan includes a few key documents that work together to make sure your money and property gets passed on the way you want, and that your medical and financial affairs are taken care of if you can't take care of them yourself. So the core documents typically included in an estate plan are a last will and testament, and possibly a revocable living trust. We'll talk more on that later. A living will, a durable power of attorney, a healthcare power of attorney, and HIPAA authorization. So individuals with more complex situations or with high net worth will often make use of additional things such as trusts, but we'll not go into that level of detail today. This guide is meant to outline the basic set of estate documents that most people should have as a foundation. So let's start with the last will and testament. Some people just say a will for short. So a last will and testament's a legal document that outlines how you want your assets and property to be distributed after your death. It also allows you to appoint a guardian for any minor children. So a will is kind of a keystone or important part of a comprehensive estate plan to help make sure your wishes are carried out and your loved ones are provided for after your death. So in a will, you can specify things like who you want to inherit your assets, such as home, car, personal belongings, bank accounts, etc. You can also specify who you want to serve as an executor of your estate. The executor is the person who will be responsible for carrying out the terms of your will and overseeing the distribution of your assets. It's important to note that a will does not take effect until after your death. This means you can make changes anytime while you're living, as long as you're mentally able to do so, the mental capacity to do so. So it's also important to have your will properly executed. We'll talk more about that later. Generally, it has to be signed and witnessed according to the laws of your state. Again, we'll talk more about those things later. All right, next, a living will. Next document is a living will. A living will is also known as an advanced healthcare directive or healthcare proxy, and is a legal document that outlines your wishes for medical treatment if you're unable to make decisions for yourself. This can include decisions about treatment, pain management, medical care, life-sustaining treatment, what types of treatment you might want to sustain your life under various tragic circumstances. And so a living will generally goes into effect when your doctor determines that you're unable to make decisions for yourself because maybe you're unconscious, maybe you're in a coma, maybe you're incapacitated in some fashion. And at that point, the living will serves as a guide for your doctors and loved ones who can make decisions about your medical care based on your wishes expressed in that living will. So in a living will, you can specify the types of medical treatment you do or don't want to receive, such as artificial nutrition, hydration, pain management. You can also appoint a healthcare proxy. We'll talk more about that later, who will be responsible for making decisions about your medical care if you're unable to do so for yourself. So again, just like other legal documents, living will needs to be properly executed according to the laws in your state. We'll talk more about that later as well. Next document, durable power of attorney. So a durable power of attorney is a legal document that allows you to appoint someone to manage your financial affairs if you're unable to do so yourself. So the person that you appoint is known as the agent or attorney in fact, and they can make decisions about your assets and property pay your bills, handle other financial matters on your behalf. The power of attorney generally goes into effect when your doctor determines that you're unable to make decisions for yourself because, again, you're incapacitated in some fashion. There's more than one type of power of attorney. The durable power of attorney takes effect immediately. There's also another type called a springing power of attorney. A springing power of attorney goes into effect when it's determined that you are incapacitated. There's pros and cons to each. Generally, I mostly see a durable power of attorney going into effect. Some people opt for a springing power of attorney, and they want to only have their agent able to make decisions on their behalf if they're incapacitated. So again, there's pros and cons. One of the cons can be there can be sometimes ambiguity on who determines incapacity and what determines whether you're incapable or not. So it just kind of depends on your preference, but be aware there are different types of power of attorney. Durable power of attorney is the one I see most often, though. Next, healthcare power of attorney, also known as a healthcare proxy or a medical power of attorney. That's a legal document that allows you to appoint someone to make decisions about your medical care if you're unable to do so. That person is known as your healthcare agent or proxy, and they're responsible for making decisions about your medical treatment based on your wishes and best interest. So again, this typically goes into effect if you can't make decisions for yourself. And so that healthcare power of attorney allows that person to make decisions on your behalf about, treatment, pain management, other medical care. But you can also place limitations and restrictions on that agent's powers as well. So that can be customized based on your desires. Next, HIPAA authorization. So a HIPAA authorization allows you to determine who can have access to your protected health information, PHI, your medical records. So under HIPAA, healthcare providers are required to keep your PHI confidential unless you specifically authorize them to share it with certain individuals. So the HIPAA authorization allows you to document which individuals can have access to your medical records. A lot of people think that a spouse or a family member automatically has access to your medical records by nature of the relationship. Not always so. That is actually not the case. Sometimes medical providers will refuse to share medical information even with a spouse or a family member because they don't have explicit HIPAA authorization. So a HIPAA authorization document will help streamline the process of sharing your medical records with those who you would like to have access. All right. I said we'd come back to this. A revocable living trust is something that is sometimes part of the set of estate documents. Not always, but sometimes. So some individuals and families do opt to include a revocable living trust in their estate plan. So a revocable living trust is a type of trust that allows you to manage your assets and property during your lifetime and specify how you want assets to be distributed after your death. A revocable living trust is called a living trust because it's created and funded during your lifetime as opposed to a testamentary trust, which is created and funded after your death through your will. So a living trust is something you maintain and operate as you're living. It's also called revocable because you can make changes anytime. You can terminate it, you can update it, you can replace it. All those things can happen during your lifetime, and that's what makes it revocable. You can make those changes. So you're called the grantor or the settlor of the trust. A grantor is typically the term used, meaning you're the person who creates the trust and transfers assets into it. You'll also, while you're living, serve as the trustee of the trust. When you pass, others can become the trustee of the trust. So after your death, the assets of the trust will be distributed according to the terms of the trust specified by you in that trust document. So this means you can specify exactly who you want to inherit assets, how you want assets to be distributed without the need for probate court. That's one of the advantages of a trust is it bypasses probate. So it can be useful in a lot of ways, and we'll talk about some of the pros and cons here for a minute. So some of the pros of a revocable living trust are that it avoids probate, as I mentioned. Probate is the legal process by which the court oversees the distribution of a deceased person's assets. This can be time-consuming and costly. Sometimes it can take months or years even to go through probate. It can also cause stress and conflict among family members as well. So a revocable living trust can help you specify how you want assets to be distributed immediately without the probate process. It bypasses probate. You can also manage assets and have flexibility on how assets are distributed after your death in a very customized fashion. It's got a high degree of flexibility. So, for example, if you want to specify that after your passing, your minor children only have access to certain parts of your estate, or maybe a certain portion of your estate or assets until they reach a certain age, and you can kind of decide exactly what ages those minor children can receive distributions based on your wishes in that trust. So you've got very fine-tuned, flexible control using a trust as well. There's also some downsides of a trust. One is complexity. It's a more complex legal instrument to maintain and manage. You've got to transfer assets into the trust. It's more expensive to create. It's just a more complicated instrument. Another is cost. It can be more costly. If you hire an attorney to do this, they're going to charge more for a trust. Even online services charge more for a trust, so there is some cost there as well. So overall, the pros and cons of a revocable living trust are going to depend on your situation. So weigh the pros and cons. One thing to be aware of is one thing I see very often is one of the more complicated parts of using a revocable living trust is placing your home into the trust. That's a pretty common act when you're setting up a trust, is placing your home into the trust so that, when you pass, or if you're, married or have a partner, you and your partner pass, then that is when your home ideally is in the trust. It passes in the trust or exists in the trust. So getting that to fund the trust is kind of complicated. There's a couple of ways to do it depending on your state. One way is to actually change the title on your home so it's inside your trust. That takes paperwork and notarization and going to the county recorder's office and filing stuff. So it's a bit of a pain. An alternative is to set up a transfer on death deed for your home, which transfers your home into the trust upon your death, or the death of both spouses, depending on if you're single or married. But again, that involves notarization, going to the county recorder again, filing it. So it's kind of a pain, and a lot of people are just not going to do that. So if you want to set up a trust, be aware that there is some complexity behind it. There are some advantages, but there's some complexity behind it. So, it might make sense to consider a trust if you have minor children and want detailed control over how assets are distributed. You want to avoid the time and costs of probate for your surviving family members. You want to keep the details of your property transfer private. A trust is private where probate is public. That can be an advantage. And ultimately, I think it's important to know that if you're highly organized and willing to go through the steps to properly fund the trust, then that might make sense to have a trust. So be aware of the complexity there. Even if you have a revocable living trust, you still have a will, which is called a pour-over will, which will kind of capture any property not included in your trust and sweep it into the trust during the probate process. So you still have a will if you have a trust. The will is designed to kind of capture anything that wasn't put in the trust and sweep that in. So again, that's called a pour-over will. So those are the basic estate documents. So to review those again, a last will and testament, and possibly combined with a revocable living trust, a living will, durable power of attorney, healthcare power of attorney, and HIPAA authorization. All right, so how do you get these documents created? There's a few ways to do this. One, the ideal way is talk to an estate planning attorney. That can be a little more expensive, but obviously you're going to get customized professional advice. So talking to an estate planning attorney, having them draft your estate documents for you is kind of the ideal situation. The next best thing, I think, is using an online service. There are a number of online providers that have come a long way, and I personally use one of them as well. I don't like to name specifics because things might change, or I don't want to be seen as endorsing any particular one right now, but there are quite a few popular services that let you go online for a low fee, and generally, within less than an hour, create a set of estate documents by answering questions, kind of going through a process, and it will generate the right estate documents for your particular state. Those services have come a long way, and they're actually pretty viable, so I do recommend them to clients quite a bit. And then finally, you can get some templates. Even your local library might have free templates, or there's online templates you can use and kind of fill in the blanks yourself. I don't love that option because it's, prone to error and it may not be the ideal situation, but it is an option. So how do you execute estate documents? How do you make sure they're valid? So you've got to sign the documents. The first step is to sign those documents. have those documents notarized in many cases. You're going to have to check with your state's laws. Many states do require all of these documents to be notarized, possibly witnessed as well. So again, you're going to want to check with your estate attorney or the online service you use, and they will kind of guide you on the right process for your particular state. Or check with your state's laws directly and just kind of see what the laws are for executing estate documents properly. And then you want to store them safely. So I recommend putting your estate documents in a fireproof safe in your home. Those are the originals. And then I like to scan the executed copies with the notarizations on them and file them online somewhere in a secure cloud system, and then send copies to everyone named in those estate documents as well. Things like your executor, your trustees, your HIPAA authorized individuals, your power of attorney agents, healthcare proxies, anyone named in those estate documents ideally should receive a copy of the documents. That's a really important step. A lot of people don't get around to the step of actually executing and validating those documents. And that's the most important part, because without that signature, the notarizations, the properly executed steps, then the documents are invalid. They won't serve any purpose. So make sure those are properly executed. So those are the set of estate documents everyone should have. Again, more complex estate situations will call for more complexity, other instruments. But everyone really should have these core set of documents. They make life easier for loved ones. When you pass, they just generally, I think it's an act of love. I think estate planning is an act of love. That may sound corny to you, but I think it really is important to set up your estate properly, because it does show love for the people that you would leave behind if you were to pass. It helps streamline their situation, helps lower anxiety, and helps lower stress at a time when they're already going to be stressed by your passing emotionally. So again, estate planning to me is an act of love. It's something you do because you love those who you leave behind. It's a way of taking care of them, making sure they're provided for even after you are gone. So with that, I hope that helps you kind of get a sense of what these estate documents do, why they're important. And as always, if you have questions about this, I always love to chat about any questions you might have, so please feel free to reach out. So to do that, you can find me on my website, which is elevationfinancial.com. There is a button on the homepage that will allow you to book a complimentary money session if you have questions, and we'll chat about whatever's on your mind, this or anything else. So feel free to reach out, elevationfinancial.com. Thanks, everyone, for joining me today. Have a great day. We'll see you next time.